Well, welcome back. Well, welcome to our studio.
Thanks, Tucson.
Welcome back to Onsite.
It's good to be here. I'm just, my office is down the street anyways.
Yeah. You want to tell people who you are and what you do?
Sure. I'm Eric Bain. I'm the owner of Bain Law Criminal Defense Law Firm in Minneapolis.
And we're going to discuss today two things that happened, I guess you could just say, regarding cops that are, or former cops that are involved in, situations regarding the court, Supreme Court, and charges, and all sorts of litigation in different terms. What, with Kim Potter, her lawyer, and just for context, Kim Potter shot and killed Daunte Wright April 11th, 2021. She was with the Brooklyn Center Police Department. She was charged with manslaughter 2 by Pete Orpit, the Washington County District Attorney, and then the case got given to Keith Ellison, and it was now charged with manslaughter 1, and her lawyer is appealing to have manslaughter 1 taken out, right?
Her lawyer filed a motion to dismiss.
Okay.
Little bit different. An appeal is different,
Okay.
but filed a motion to dismiss for the district court to dismiss the charges.
And what were the grounds for that Earl was, saying to dismiss the?
Sure. I think you're referring to Earl Gray, who's the defense attorney
Yes.
for Kim Potter. I read the filing. There are a couple of bases for it. The main basis is when Keith Ellison's office charged the first-degree manslaughter.
Yeah.
That's based on an allegation that former Officer Potter committed an assault and did so while recklessly discharging a firearm.
Yeah.
And so the basis for the motion to dismiss is that she didn't do it recklessly, was number one.
Okay.
And their recklessly has been defined, of course, legally, and the main argument is that in order to act recklessly, you have to be consciously aware of a risk and proceed with taking the risk anyway. And so the argument is that she thought she had a taser and thought she was using a taser.
Yeah.
It's not like she knew she had a gun and she decided to discharge it anyway. At least that's the argument. And if the district court believes that that element of the charge can't be met by the probable cause standard, then it must be dismissed.
And so Earl is, so it's the idea is saying that she wasn't conscious of the risk. And whereas reckless is they're conscious of the risk and they take the risk. Yeah,
you have to know that something is super risky and you do it anyway. So, for example, I guess if you are riding a motorcycle down the street and you're standing up on it, you choose to stand up, you know that that's risky, that's reckless. And so you're probably going to be charged with reckless driving, for example.
Got it, yeah.
But in this case, it's a little bit different. So that's the argument that Earl Gray, Kim Potter's defense attorney, is making.
Then you would have to prove that then it comes down to the thing in the beginning that Tim Gannon spoke about. You'd have to prove that she didn't know she was reaching for her Glock 22.
I mean, I think there's going to be a couple of things that the state's going to have to prove, and in the complaint against Kim Potter, they go, they take great pains to show that she was well trained in what a taser is versus what a firearm is. They have different weights, they have different feels. It's not like this was a rookie cop, first day on the job.
No, she's a training officer.
Yeah, she trained other officers. She had been on the job for, I think, 26 years or so.
Yeah.
And she had been through extensive trainings herself on how to operate a taser, how to operate a firearm. And so the argument that I think the state is going to make in that case is that, she knew or should have known what firearm or weapon she was holding, that it was a taser versus a gun, and that she discharged it anyway, and doing so was reckless in the moment. I should mention, though, that the other argument, and this is an interesting argument that Earl Gray is making along with his co-counsel Paul Eng, what they're arguing is that the cops, when they are authorized to use deadly force, they've had, in the past, far greater latitude. And there was a new statute that came into effect, I believe it was March 1st of this year.
Okay.
Which restricted cops' use of deadly force, and made it a little more difficult for them to assert, the defense at trial should they be charged.
Yeah.
They and the new law says that in order to use it, you have to articulate, what the threat was to you.
Yeah.
And you have to, it has to be a very dangerous situation.
Yeah.
What Kim Potter's attorneys are arguing is that the old law should apply in Kim Potter's case, even though the new law was in effect at the time of the offense, by about 6 weeks or whatever.
Okay.
And it's a novel argument. It's an interesting argument.
It's an interesting move. I would not think that somebody would say, but just a month and 11 days ago,
Sure. And part of their argument is that, there was a ruling, I think it was in Ramsey County, saying that the new law should be stayed because certain pieces of it are going to be challenged and litigated. Yeah. That's fine, but it is a bit of an interesting argument to say, oh yeah, that new law doesn't apply, even though it was clearly in effect at the time of the offense. So
yeah,
we'll see what happens with that piece of the argument as well. But that would be helpful for Kim Potter's defense, because if the old law were to apply, in theory, she would have greater latitude to use deadly force. And so the argument goes, even though she mistakenly used her firearm, she could have used her firearm and she could have shot him under the circumstances. Mm-hmm. Again, we'll see if that goes anywhere, but that's the other line of argument on the motion to dismiss.
What manslaughter, for people that don't understand what manslaughter means, wouldn't that literally be mistakenly killed somebody or killed somebody like by proximity or on an accident? Murder, I would assume, just for folks that don't understand it,
sure.
Murder, when I think of it, is just, they intended to hurt that person. Manslaughter is, whoops, I happened to just do this thing and somebody happened to die.
It's a little more complicated than that.
Okay.
And so, there can be unintentional murder and intentional murder.
Yes.
And so you don't necessarily have to intend to kill someone to be charged with murder.
Yeah.
And with manslaughter, there are a number of different degrees and scenarios in which you can be charged with manslaughter. And so, it makes sense that the first-degree manslaughter charge was added against Kim Potter. I get it. It's based on an allegation that she assaulted Daunte Wright and did so by recklessly discharging a firearm.
Yeah.
I think at the same time, an argument could be made that a murder charge could have and should have been added to the complaint as well, based on the theory that even though she maybe didn't intend to kill him, we don't know for sure, but let's give her the benefit of the doubt that she didn't intend to kill Daunte Wright. But I think an argument could be made that you could add the charge for second-degree murder, unintentional, based on the fact that death was caused in the commission of a felony. And the felony could be reckless discharge in a municipality. And she's already charged with reckless discharge of a firearm as the misdemeanor predicate offense for the first-degree manslaughter. So if the state really wanted to, it is a felony to recklessly discharge a firearm within a municipality. This was in Brooklyn Center. It was clearly within a city.
What does that mean, within a municipality?
It just has to be within a city.
Okay.
It's not a felony to recklessly discharge a firearm out in the boondocks, out in the states.
Good. That's good to know.
But that charge wasn't added and hasn't been added. I don't know if it will or won't be, but nevertheless, it was interesting to me and it caught my attention that they decided to go with the first-degree manslaughter instead of the second-degree murder charge.
Well, second-degree murder, for those that are, and I've read this over ever since I spoke to you the first time, speaking on depraved of the mind, being third degree, but murder 2 in Minnesota causes the death of a human being without intent to affect the death of any person, while intentionally inflicting or attempting to inflict bodily harm upon the victim. That to me, it seems like the literal term of what I saw in that video. It's without the intent to affect the death of any person, but causes the death of a human being. And so
an argument can be made that that charge could be there, I think. And prosecutors have, wide discretion. I mean, it's their case. They can charge what they want, what they think they can get in terms of, a reasonable probability to get a conviction at trial.
Yeah.
And if they're not charging something, the assumption is that the prosecutor doesn't think that he or she can get that conviction from a trial or get that guilty verdict after a trial. Again, when it's the state charging a cop, it kind of flips things on its head a little bit, and you always start to wonder, are they really pursuing as aggressive prosecution as they can against a cop or not? And I think we'll never really know, but the optics sure look like when the Washington County Attorney's Office made a charging decision for Kim Potter, it at least looks now like they undercharged, and it at least looks now like the Attorney General's office, by bringing in more severe charges, at least are bringing the perception that they are aggressively prosecuting cops. And the same thing happened with Derek Chauvin. It wasn't until Keith Ellison's office came in that the additional charge was added of murder 2.
What was the original charge that Freeman had made?
I believe it was just murder 3 and then the manslaughter 2.
Wow.
But it was Keith Ellison's office that brought in the murder 2 charge. And
Well,
they actually got a conviction for it. And that was the top count, the top charge, and that's what he's sentenced on.
And it wouldn't be far off to say that if it was just at murder 3 for Chauvin, they may not have gotten that. I mean, depraved of the mind, or just like.
I hear you. Yeah. I mean, they did. They did. We now know it's going to be overturned.
Yeah.
Which is a separate conversation.
We'll get into a little bit later. Oh goodness. And so, I guess I didn't pay as close attention as I wanted to. Did they toss out the manslaughter 1 account for Kim Potter? Did
they toss it out?
Well, I mean, did they dismiss it as Earl Grey tried to get it dismissed?
Well, the stage of the case. The judge hasn't ruled on it yet.
Okay.
I think the motion to dismiss was maybe filed last week or something.
Okay.
And so the judge will hear the motion and rule on it, but a ruling hasn't come yet.
Okay. And they can't up charges to they can't up charges to murder 3 or 2 at all. What's kind of been submitted has been submitted, and that's.
They can amend the complaint any time before a jury is impaneled.
Okay. Interesting. Well, thank you for informing us on what that meant for Earl Grey to submit to have manslaughter 1 dismissed and what it could be going forward. So yeah.
Yeah, and the trial for Kim Potter is coming up at the end of November. I'm sure
no cameras, no recordings.
No, not this one.
No.
Not this one. Back to normal.
Yeah. Okay. Why? Well, as we wrap up, why is that? Why is that to protect folks in the court, or what is the kind of the meaning or impetus behind not being able to record anything in a court or in a trial?
Yeah, Minnesota has had a long-standing aversion to cameras in the courtrooms.
Yeah.
And really, an exception was only made for the Chauvin trial, I think because of the international news coverage.
Yeah.
And number 2, it was COVID. And Hennepin County District Court, they just have small courtrooms.
Yeah.
It's a older building, and the courtrooms aren't big. The galleries are pretty small. And so to accommodate the press in a way that was fair, I think they kind of said, we have to do this live stream, because then we're going to be picking and choosing which news outlets we let into the courtroom.
Yeah.
And also, it was COVID. It still is COVID.
Yeah.
And so as a way to kind of keep people out of the courtroom, they decided to do it. The other thing, and it's a more practical reason for it, is there's a theory that lawyers tend to showboat if they know they're being on TV.
Would assume as such, yeah.
And the courtroom really isn't a place for that.
No,
the audience is not out there. The audience is the jury box.
Exactly.
and the judge to an extent. And the other thing is, not always, but many times, there are witnesses in a case that don't want to have their identity public, that
Makes
don't
sense.
want to, have their names and faces blasted out there.
Yeah.
And Judge Cahill in the Chauvin trial had to make a difficult decision, and one piece of fallout from all of that is, some of the younger people that were called as witnesses.
They were put up in front of the world.
Yeah.
Last thing before we sign off on the Potter trial. What does it mean if manslaughter 1 gets dismissed? What does it mean versus it staying?
It means that, in practical terms, Kim Potter would not stand trial on that charge, and so the state would only have to prove the charge that still remains. But the real reason the state goes after a higher charge is to get a longer sentence, and so if the manslaughter in the first degree gets dismissed, Kim Potter is automatically looking at a much lower sentence.
Okay.
So on the lower count, I believe it's about a 48-month prison commit. Is
so
the guideline sentence
for man 2?
It would be 48 months, so about 4 years.
Oh, 4 years. Yeah.
Yep. And then on the first degree manslaughter, I think it's about 86 months or so.
Okay.
So a pretty, about almost double
Yeah.
the sentence. And so if manslaughter 1 goes away, then worst comes to worse, and she loses for her, then her sentence would be about half of what it could be.
Okay. Well, thank you for educating us on that, and we look forward to seeing how things unravel and talking to you more about what things mean and what they don't mean.
Of course. Thanks for having me.